We are recording.
All right, good afternoon, everyone. Welcome to the Appellate Court. I'm Judge Bright. I'm sitting this afternoon with Judge Mall and Judge Baer on the matter of Bayview Loan versus MACRAE-GRAY. The docket number is AC 43805. This argument is being conducted over the Teams platform, so everybody is appearing virtually. The judges are appearing by video conference. Attorney Carnelli, on behalf of the appellee, is appearing by video conference, and the appellant, Mr. MACRAE-GRAY, is appearing by phone connection today. In addition, the argument is going to be streamed live on the branch's YouTube channel and will be posted on the branch's website, both the audio and the visual, for anybody who wants to see it later. I'm going to ask everybody to identify themselves for the record so that we can make sure we can hear and see each other okay. I'll start with the judges, then the appellant, then counsel for the appellee. Again, I'm Judge Bright.
I am Judge Mall.
Judge Baer.
I am Glenn MACRAE-GRAY, the appellant. Hello, Your Honors.
Hello.
Good afternoon, Your Honor. May it please the court. Dennis Carnelli of Newburgh, Pepe, and Monteith for the plaintiff and appellee, SC Park Lane 2.
Okay. All right, I can hear and see everyone okay. I'm assuming everyone can hear each other okay, and that everybody is visible to everyone except for the appellant. If for whatever reason you are not able to hear anybody, please let us know. And if you get disconnected from the conference, please go back to the link and try to log back in. We will suspend the argument until I'm sure that we have everybody present. Although we are conducting this argument virtually, everybody should treat it as if we are arguing in person in the appellate court here in Hartford and conduct themselves accordingly. I would ask, though, that when you're not speaking, that you mute your microphone so that we can avoid any background noises and avoid talking over each other. The judges will do the same thing. I would ask, though, just for Attorney Carnelli, that you keep your camera on at all times so we can make sure you're still present and appropriately engaged in the argument. Each side will have 20 minutes to argue. The appellant can reserve time for rebuttal. I will keep time. Mr. MACRAE-GRAY, when you have 2 minutes left, I will alert you to that fact. And when you have 1 minute left, I will alert you to that fact. And then I will tell you when your time is up. Okay?
Thank you.
All right. Are you ready to proceed?
I am ready to proceed.
All right. How much time would you like to reserve for rebuttal?
Not having heard what they have to say, I'm not exactly sure. My notes here will take almost 20 minutes to give to the judges to evaluate.
Okay, so you have a total of 20 minutes to argue, and you can go up to those 20 minutes, and if you use the full 20 minutes, you'll have no time for rebuttal, and if whatever you don't use of the 20 minutes, I'll take note of, and you'll have that time for rebuttal, okay?
Thank you very much.
All right, you may proceed.
Thank you. I am Glenn MACRAE-GRAY. This case brings to vitally necessary state and federal judicial and law enforcement attention the most nationally widespread and damaging criminal enterprises that have ever victimized both Americans and our country. The appellee's original multiply illegally written and executed papers were perpetrated upon our family, leading up to Citibank's now infamous residential mortgage-backed securities lawsuit that was settled on July 14th, 2014 by the United States Department of Justice and states attorney generals for a record $7 billion. This goes to establish the multiple illegalities of the appellee's original illegally written and executed papers. I have established in my court filings numbers 143 to 151, including my substantiating exhibits A to F and brief, appendix and reply brief and appendix, that the appellee's original papers were multiply criminally and otherwise illegally written and executed in violation of all the specified court rules, statutes, constitutional provisions, decisional law, and this code in the Code of Judicial Conduct's terminologies, definition of law. Thus, the original papers were never a legal contract pursuant to ex turpi causa non oritur actio. I have also established in my brief, appendix, reply brief, and reply appendix that again and separately, all summary judgments are an obvious violation of the Code of Judicial Conduct's definition of law, specifically constitutional provisions. Therefore, pursuant to my briefs, pages 11 and 12, my appendix, pages A72 to A76, my reply briefs, pages 3, 5, 7, and 10 to 12, and my reply appendixes, pages A5 to A14, that Judge Shaban's and Judge Moore's judgments are in violation of the superseding laws that are the Constitution of Connecticut, Article 1st, Section 19, and substantiated multiple violations of the 14th Amendment to the Constitution of the United States, and are therefore multiply unconstitutional and illegal, that again and separately render Judge Shaban's and Judge Moore's decisions 143.2 and 152.1, and Judge Moore's decisions 178 et al. Null and void. I have also established in my appendix that, but not limited to, Judges Shaban and Moore violated the Code of Judicial Conduct, substantiated on pages A68 to A71 of my appendix, because they adjudicated both invalidated motions for summary judgment that render their decisions and the lower court's orders null and void. Judges Shaban and Moore multiply violated, but not limited to, the Code of Judicial Conduct's Canon 2, Rule 2.2, that includes court rules in the Code of Judicial Conduct's definition of law, because in the plaintiffs' and their lawyers' objection to my motion for summary judgment, entry number 157, Attorney Adam D. Lewis admitted on the first page that there exists triable issues of fact, and in the same filings, section 4, conclusion, that a review of the evidence proffered by the parties shows that a genuine issue of material fact exists. The practice book's section 1749 states, the judgment sought shall be rendered forthwith if the pleadings, affidavits, and any other proof submitted show that there is no genuine issue as to any material fact. However, the plaintiffs and their lawyers admitted that there exists triable issues of fact, and in the same filings 4, conclusion, that a review of the evidence proffered by the parties shows that a genuine issue of material fact exists. Therefore, the above admissions by the plaintiffs and their lawyers established that there were genuine issues as to any material fact that invalidated both motions for summary judgment and Judge Shaban's and Judge Moore's rulings on those motions. Thus, the plaintiffs and their lawyers' above admissions immediately rendered both the plaintiffs' and the defendants' motions for summary judgment null and void, and not adjudicated pursuant to the above-cited practice books section 1749 because of the plaintiffs' and their lawyers' above admissions. Therefore, Judges Shaban and Moore multiply violated Canon 2, Rule 2.2, because Judges Shaban and Moore ruled on motions for summary judgments that had previously been invalidated by the plaintiffs and their lawyers' above admissions that rendered both filed motions for summary judgment and Judges Shaban's and Moore's rulings on those motions to be invalid, null, and void. As adjudicating judges, both Judges Shaban and Moore were obligated to immediately issue a court order that this case be put on the trial list because of the plaintiffs and their lawyers' above admissions. Thus, the plaintiffs and their lawyers' above admissions invalidated both the plaintiffs and the defendants' motions for summary judgment because the plaintiffs and their lawyers' above admissions immediately disqualified both motions for summary judgment pursuant to the practice books section 1749. I have also established in my court filings that Judges Shaban and Moore violated, but not limited to, the Code of Judicial Conduct's Rule 2.2 by ruling for all the outright substantiated violations of statutes, policies of the law, and civil offenses that establish that they have ruled for and sustained all of the multiple criminal and other illegalities I substantiated in my court filings. I have also multiply established in my brief on pages 11 and 12, my appendix on pages A68 to A71, my reply brief on pages 5 and 12, and reply appendix on pages A9 to A14, that Judges Shaban and Moore have violated their judicial oath of office, Article 11th, Section 1, to support the Constitution of Connecticut because they have violated, but not limited to, Article 1st, Section 19, by unconstitutionally and illegally denying me my state constitutional right to trial by jury. I have also established in my reply appendix on pages A9 to A14 that Judges Shaban and Moore have also violated their judicial oath of office, Article 11th, Section 1, to support the Constitution of the United States. Thus, Judge Shaban's and Judge Moore's multiple violations of statutes, policies of the law, civil offenses, and their constitutional oath of office invalidates Judge Shaban's rulings 143.2 and 152.1, and Judge Moore's derivative judgments number 178 et al. Because of their above substantiated violations that render those rulings invalid, null, and void. I therefore respectfully request that Your Honors take action against Judges Shaban and Moore pursuant to the Code of Judicial Conduct and Chapter 872A, Sections 5151G through 5151U for their obviously grotesque, unjust rulings in support of multiple lawlessness that have brought their inexpressible injustice and dishonor to the judicial system of Connecticut. Judge Shaban's and Judge Moore's violations of, but not limited to, the Code of Judicial Conduct require Judge Shaban's and Judge Moore's removal from office as judges pursuant to the lawful enforcement of Chapter 872A, Sections 5151G through 5151U of the Connecticut General Statutes by, but not limited to, the Supreme Court of the State of Connecticut. Additionally, I have also established in my court filings numbers 143 to 151, including my substantiating exhibits A to F, that the opposing lawyers have also violated their attorney's oath and court rules 1.16, A1, Rule 1.16, B3, Rule 1.2, D, Rule 2.15, B and D, and Rule 8.4, Misconduct 1, 3, and 4, that I substantiated in, but not limited to, my court filings numbers 143 to 151. 143 to 151. Because their lawyers have necessarily read all the previous court filings and have still taken this case, their offenses include all the appellee's violations of statutes and frauds on the court. which constitute that they are knowingly criminal accomplices after the fact. The lower courts and appellees' lawyers are knowingly criminal accomplices after the fact because my exhibits A to F are prima facie evidence that they are knowingly representing part of the largest series of criminal enterprises that have harmed both Americans and our country by their substantiated criminal and other violations of statutes, policies of the law, and civil offenses, in addition to the multiple specified violations of laws and court rules in my court filings, each one of which invalidates the appellee's entire action. I restate that this case brings to vitally necessary state and federal judicial and law enforcement attention the most nationally widespread and damaging criminal enterprises that have ever victimized both Americans and our country's economic strength. These criminal and other violations of state and federal statutes, public policies, and civil offenses include all the violations specified in, but not limited to, my brief on pages 12 to 31, and further substantiated on pages A45 to A58 of my appendix. The multiple violations of statutes in my lower court filing entry 143 on pages 120 to 169 include in detail the nationally perpetrated criminal enterprises of clerical counterfeiting obligations of the United States that are specified on my briefs, pages 24 to 28, and substantiated by the multiple admissions in my exhibits C to F. We have all lived through the effects of the criminal enterprises that clerically, illegally, quote, fund, unquote, all of their illegally and fraudulently made alleged, quote, loans, unquote, including alleged, quote, loans, unquote, to your honors, by criminally, clerically uttering, passing, and dealing in illegally uttered obligations of the United States in violation of 18 United States Code, sections 471, 472, and 473. This has resulted in the devaluing of our national currency such that prices for everything have risen to what were unimaginable levels. I remember that in the late 1950s, hamburger was 46 cents a pound. Now it is selling for around $5 a pound. A can of soup was 10 or 12 cents, but recently I paid $1.79 for each can of specially price-reduced chicken noodle soup. As I have written in my court filings, numbers 143 to 151, these seemingly legal but actually criminal enterprises have illegally devalued the worth of our national currency, severely damaged the economic strength and security of the United States, and have destroyed thousands of Americans by stealing their homes, cars, and money through their illegal defrauding of both their victims and our judicial system by their multiple violations I have detailed in my court filings and exhibits. Although each of the appellees substantiated violations of statutes, policies of the law, and civil offenses equally invalidates their multiply criminally and otherwise illegally based action. I direct Your Honor's special attention to the appellees and their lawyers' substantiated frauds on the court on page 31 of my brief, on pages A59 to A65 of my appendix, and on pages 3 and 6 to 9 of my reply brief. As cited in my brief's table of authorities in case law, in Bullock, Kenner, in re-petition to annex certain territory, and the people of the state of Illinois, on Roman numerals page 13, the Supreme Court of Illinois ruled, the maxim that fraud vitiates every transaction into which it enters applies to judgments as well as to contracts and other transactions. Thus, the above case law precedents that are also cited on pages A59, A63, and A65 of my appendix have ruled that the plaintiffs and the appellees' frauds on both the lower and appellate courts invalidate Judge Shaban's and Judge Moore's court orders. I therefore respectfully also request that your honors and the appropriate judicial authority take action against all the lower courts plaintiffs' relevant lawyers and the appellees' relevant lawyers for their multiple substantiated violations of the Code of Professional Conduct, because my court filings and exhibits have substantiated that the original papers upon which the appellees have sued were multiply criminally written and executed. All of the appellees and their lawyers' pleadings and exhibits are null and void because of their multiple illegalities, violations of policies of the law, civil offenses, frauds upon the court, and but not limited to Judges Shaban's and Moore's multiple violations of Chapter 872A, Sections 5151G through 5151U of the Connecticut General Statutes, including but not limited to the Code of Judicial Conduct's Rule 2.2. Thus, all of the appellees' pleadings and exhibits are of no legal validity, and I respectfully request that your honors uphold and apply the law pursuant to the Code of Judicial Conduct's Rule 2.2 by reversing the lower courts' violations of the Code of Judicial Conduct, simultaneously ruling for our country's just laws and
2 minutes left.
Me as the court deems just and fair for the appellees bringing their multiply criminally and otherwise illegally based ex turpi causa non oritur or act actio suit against my late mother and brother and myself. For the most good that can come out of this case, I respectfully request that your honors shall uphold and apply the law pursuant to Rule 2.2 by both requiring state and federal law enforcement agencies to stop all the illegalities I have specified, including the clerical counterfeiting of alleged loans, and sufficiently compensate me financially such that I am able to advance my medical research's cure for atherosclerosis, heart disease. We all have varying amounts of this fatal disease, but do not know we have it because we do not have...
You have 1 minute left.
Thank you. We all have varying amounts of this fatal disease, but do not know we have it because we do not have nerves that transmit impulses from our arteries to our brains that tell us that our arteries are damaged, frequently severely. I will need at least an estimated $12.75 million to do the proof of concept test I designed that will establish how rapidly my invention works at different serum concentrations to systemically and completely eliminate atherosclerotic plaque from all human arteries, including the smaller coronary arteries of the heart to larger vessels of the body and neck. I thank you.
That was well timed. You used almost exactly 20 minutes. So your time has expired. Attorney Carnelli, you have 20 minutes.
Thank you, Your Honor. For the reasons set forth in my brief, I would ask that the trial court judgment be affirmed. And unless the court has any questions for me, I will rest on my brief.
I do not see any questions from any members of the panel, so we will take the matter under advisement. I want to thank you all for your patience as we worked out our technical issues before the argument. Thank you all for participating in the virtual courtroom today. I hope you have a good day. We will stand in recess until 4 o'clock. Thank you.
Bye. All again.
All right.
Thank you. Goodbye then.
Bye-bye.